Suit seeking sack of Rivers Sole administrator suffers setback. A suit filed by an Abuja-based lawyer, Mr. John Mary Jideobi, seeking the sack of the recently appointed sole administrator of the Rivers, Vice Admiral Ibok Ete Ibas, retired, was stalled on Thursday due to inability to serve some defendants. Now today, they were unable to serve some defendants. Can you imagine? The development occurred after the plaintiff's counsel, Chimezie Enuka, informed Justice James Omotosho of the Federal High Court in Abuja that he was unable to serve the Zamfara and Bauchi states, who are the 8th and 9th defendants in the suit, with hearing notice of the matter. How were you unable to serve them? How? You could not reach the place, or there is no transport that is going there, or what? At the Thursday's proceeding, only the Attorney General, AG of Lagos, Bayelsa, Taraba and Edo were represented in the court out of the 36 state government AG that were listed as the defendants in the suit. Enuka told the court that he would ensure that all the defendants are served on or before April 13. Very funny. He therefore sought an adjournment to enable him to do the needful. That's how they'll be doing now. That's how they'll be doing. Adjourn. Tomorrow is April 13. I'm not going to adjourn it. So let's say what the date that the judge will adjourn it to, because that's how they'll be adjourning. He therefore sought an adjournment to enable him to do the needful. Justice Omotosho, with the agreement of lawyers, I've seen the date too, that's why I'm laughing. With the agreement of lawyers in the matter, adjourned the matter until June 11. Did you hear that? June 11. We are in what? April, May, June. What happened to April 20-something? What happened to May? You have to go all the way to June. Adjourn it. By that June 11 now, they will come. They will now read all the defendants, whatever. When they now finish reading it, they will adjourn again. Next hearing. Maybe they will adjourn that one to December. The News Agency of Nigeria now reports that Jideobi in the suit marked FAC/ABJ/CS/572/2025 listed President Bola Tinubu as the first defendant. He also named the Attorney General of the Federation, AGF, Vice Admiral Ibas, retired, and Attorneys General of the 36 states of the Federation as second to 39th defendants, respectively. The plaintiff in the suit is praying the court to set aside all actions and decisions, howsoever described or made, of the third defendant, Vice Admiral Ibas, retired, in the name of sole administrator of Rivers State, same being unconstitutional, null, and of no constitutional force throughout the Federal Republic of Nigeria for all purposes. The plaintiff further prayed the court to issue a perpetual order of injunction restraining the first defendant, Tinubu, either by himself, his officers, agents, privies, servants, or any other person acting under his command, howsoever named, from either removing, suspending, or otherwise tampering with the tenure of the governor and deputy governor of Rivers State, and indeed any other state in Nigeria. He equally sought an order of perpetual injunction barring President Tinubu, either by himself, his officers, agents, privates, servants, or any other person acting under his command, howsoever named, from appointing any sole administrator into any state government house in the 36 states of the Federation for any purpose whatsoever. Those ones. They are still going to declare state of emergency. People should just be looking. In the originating summons, the plaintiff prayed the court to determine whether, in the view of the combined provisions of the entirety of Section 1, 5, Section 2, 180, 188, 189, 305 and 306 of the 1999 Constitution of the Federal Republic of Nigeria, the President has any constitutional authority to either remove, suspend, or otherwise tamper with the tenure of the duly elected governor and deputy governor of Rivers. Upon the determination of the question, he prayed the court to declare that, upon an intimate reading and complete understanding of the entirety of the Section 305 of the 1999 Constitution, as amended, there is no circumstance contemplated by the Constitution for the removal or interruption of the tenure of an elected governor and deputy governor of a state, except the circumstances contemplated under Sections 180, 188, 189, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended. That Constitution, it's not working. A declaration of this Honorable Court that in view of the entirety of Sections 1, 5 subsection 2, 180, 188, 189, 305, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended, the President of the Federal Republic of Nigeria has no constitutional authority to either remove, suspend, or otherwise tamper with the tenure of a duly elected governor and deputy governor of a state, and appoint a sole administrator or any other substitute howsoever called or described, such as the third defendant herein for that state. Let them come and explain to us if truly the president has the power, the capabilities to do all of this. A declaration of this Honorable Court that the purported suspension of the governor and deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th day of March 2025 is unconstitutional, null, and void, and of no legal effect whatsoever. Let's see if this person is really going to win this case. This one that they are already adjourning into June 11. A declaration that the purported nomination, appointment, and swearing in of Vice Admiral Ibas retired by the first defendant as the sole administrator of Rivers State of Nigeria is unconstitutional, null and void, and of no legal effect whatsoever. An order setting aside the suspension of the governor and the deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th of March 2025 for being unconstitutional, null and void, and no legal effect whatsoever. Now, wow, this thing won't go. In a 32 paragraph affidavit deposed to in support of the suit, the plaintiff maintained that though President Tinubu has the constitutional power to declare a state of emergency in deserving circumstances in any part of the Federation, he does not have the power to suspend elected officials like a governor who is not his appointee. You are not the one that appointed him, so you cannot remove him, but you did, which is unconstitutional. As a Nigerian lawyer and all through my years of practice, I have never seen the word sole administrator, in the amended 1999 Constitution of the Federal Republic of Nigeria. Can you imagine? Really? I know that neither the first defendant nor the second defendant appointed the governor and deputy governor of Rivers State of Nigeria, and that no governor or deputy governor of Nigeria is an appointee of the first and second defendants. I know that Nigeria practices federalism hinged on separation of power. I'm genuinely worried that in the absence of the intervention of this court, removal of duly elected governors and deputy governors may become the pastime of the president, thereby opening the floodgate of anarchy capable of consuming the nation. It would be in the interest of justice for the Honorable Court to grant the prayers contained on the face of the originating summon. The plaintiff have had none. Hopefully, let's see if they are going to listen to all your complaints, all of this, because I don't know. It is well. And listeners, what do you think? Leave your thoughts in the comment section. Don't forget to like, to share, and subscribe. Thank you for listening. See you some other time. Bye.